case number 2024-291945FC and 2024-291950FC.
Good afternoon, Your Honor. May it please the Court. John Petrofessa and Andrew McGarrow on behalf of the people.
Good afternoon.
Good afternoon, Your Honor. Michael McCarthy, P30169, on behalf of Joshua Zuazo. He's seated in the jury box.
Hello, Michelle Lofton on behalf of Carlos Hernandez, who is seated in the jury box as well.
All right, good afternoon to all of you. Date and time for sentencing. I have had an opportunity to review the pre-sentence report. Is there any additions, deletions, or corrections as it pertains to Mr. Zuazo?
Your Honor, as to the pre-sentence report, no. I do not have any objections to the personal background information regarding Mr. Zuazo.
They can both stand up. You're being sentenced. Stand up.
And Mr. Zuazo and I met a few days ago. We went through the report together, and he confirmed that the report itself is accurate. I do have one objection to raise to a sentencing guideline assessment, but beyond that, as far as the report itself goes, no objections.
Well, which guideline?
It is OV, offense variable 19, and the assessment is for 10 points for otherwise interfere with the administration of justice. And what I would relate, in my understanding of the factual record, is that Mr. Zuazo was arrested, I believe, on the 14th day of October last year. He was on a job site. A SWAT team came in to make that arrest. He was cooperative at the time. He did not otherwise interfere with the administration of justice. That was the first time he had any encounter with law enforcement as far as the investigation of this case goes. And I don't know of any time after his arrest that he otherwise interfered with the administration of justice. So it's for that reason that I'm raising an objection to the assessment of 10 points for OV-19. And I will tell the court that the total score is 120 points, the offense variable score, and so it's not going to make any difference in terms of what the guideline range is, but I don't want, as trial counsel on behalf of Mr. Zuazo, to let what I believe the ruling is to go unchallenged.
And just to be clear, we're obviously not talking about the felony murder. You're talking about the guidelines as they pertain to count 2 and 3.
That's correct.
Okay, what's the people's position?
Your Honor, the people believe that it's properly scored. The fact that the Sheriff's Office very efficiently tracked down the defendant and had him arrested at his house doesn't negate what he did between the murder and his arrest, which was the fact that he tried to get rid of the evidence. In fact, Defendant Hernandez had some of his evidence in his possession. He also was involved in having the vehicle that had been used in that part of the arson of that, and also the fact that the charge itself for those 2 counts does say that it was in perpetration of escaping the conviction of getting away from flight with a felony. So it's actually built into the charge.
Right. My recollection is that the defendant Zuazo went about his normal life after having committed the offense, that he went to work and was an attempt to pretend or act as if none of this had occurred. So I do think that OV's properly scored and that he did obstruct justice but by not cooperating and participating in that aftermath of this murder. Anything else?
No, that is...
Judge, regarding Mr. Zuazo, before we leave him to talk about Mr. Hernandez, we have to address the habitual offender notice,
Okay.
which was properly given. People believe that all 3 of those convictions are referenced in the PSI. I believe the defendant acknowledged the PSI was correct. The first one, the habitual, regarding a prior conviction for a prisoner possessing a weapon that occurred in the year 2015. That's referenced in the PSI as number 6 of 7. The second prior conviction, which was an armed robbery conviction out of 2010, was also referenced in the PSI as number 5 of 7. And the third prior conviction for felony receiving, concealing stolen property of a motor vehicle out of 2005 is reference number 4 out of 7. I do think the court needs to take notice of that. For the record, it does affect the guidelines.
And you agree that that's accurate, Mr. McCarthy?
Yes, Your Honor.
All right, the court is going to take
Mr.
notice.
Zuazo confirmed all of those convictions when we went through the report this past Saturday.
Okay, all right, the court's going to take notice of the defendant is in fact being sentenced as a habitual 4.
Thank you, Judge.
All right, Ms. Lofton, any changes on behalf of Defendant Hernandez?
Nothing to the report, but I do have 2 separate guideline issues that I'd like to address.
Okay, go ahead.
OV1, This is in conviction count 2 of 3, so the unlawful imprisonment. OV1 is currently scored at 10 points. OV1 is aggravated use of a weapon. 10 points should be scored if the victim was touched by any other type of weapon. In all of the testimony that was presented, I don't believe that it was proven or even mentioned that a weapon was used. If we are to believe that this assault took place by fists, I say that it absolutely should not be scored. He wasn't touched by a weapon. Mr. Hernandez is not charged with any offenses relating to a weapon, so I don't believe it's properly scored. OV2 also piggybacks on that same line of thinking. OV2 is lethal potential of weapon possessed or used. He is currently scored at 1 point. 1 point should only be assessed. It says the offender possessed or used any other potentially lethal weapon. I argue that that was absolutely not proven at trial.
Okay, people?
Judge, starting with her last argument first, the court is very aware that the testimony showed that the victim had and carried his sidearm. That sidearm was missing. It was never recovered, so he was possessed. It was missing. The defendants did take that weapon. He was in possession or aiding and abetting the possession of a weapon. So I think that is just logically consistent. And I think the court did hear that.
Does the weapon have to be used in the course of the crime?
One is the possession of it, correct, and then for her first argument, you heard the testimony of both the first responders who described the scene and initially thought that it was gunshots. That's how horrific the scene was to them. And then you heard the medical examiner's testimony talking about the blunt force trauma, indicating that a weapon was also consistent with being used in that. There was also the weights that were found right next to him that had lots of blood on it. I believe that you could find from the preponderance of the evidence presented that that's properly scored.
All right, the court does find that OV1 is properly scored at 10. The images that the court viewed as it pertained to the victim, Mr. Murray here, certainly could be described as being brutal in nature and not likely to have just been able to have been committed by fist. So there were items within that basement that could have been used as a weapon. So the court does think OV1 is properly scored at 10. And conversely, OV2 is properly scored at 1. Defense's objections are noted for the record. All right, any other changes as it pertains to the PSI for Defendant Hernandez?
No, Your Honor.
Okay, we're going to get to allocution.
Judge, I hate to interrupt, but again, for the habitual offender notice for Mr. Hernandez, I believe it needs to be acknowledged on the record regarding the habitual that has been filed. He has 3 prior convictions for felonies, 1 in 2012 for prisoner or attempted possession of a weapon. That's number 5 of 7 in the PSI. A 2006 conviction, 3rd degree criminal sexual conduct. That's listed as number 3 of 7 in the PSI. And a prior conviction for felon in possession of a firearm in 2006. That's listed as number 4 of 7 in the PSI. And I believe those should be taken notice of for the record.
All right, Ms. Lofton, you agree with that?
I agree.
All right, the court is going to take notice that Defendant Hernandez is also a habitual fourth offender. All right, so before we get to allocution, I'll obviously give the parties an opportunity to speak. It's my understanding you have some victims who would like to speak
Yes,
first.
the 3 sons would like to speak
Okay.
briefly, Judge.
Would you like the defendants to remain standing or be seated during the statements?
They can stand.
Hussein Murray, if you could approach. Could state your name for the record, please.
Definitely. Hussein Murray.
Good afternoon, sir.
Good afternoon, Your Honor. I have a lot on my heart that I could say to you. My brothers are going to speak as well, so to be mindful of the court's time. I'm just going to read a short poem that my mother wrote to express her feelings about this, and my brothers will speak on my behalf as well. They have stolen my sunshine. They have stolen my happiness. They have stolen my reason for living. They have stolen the love of my life. The world is darker now without the love of my life, without my companion of 54 years. The plans we made will never come true. The sadness and tears will never end. I want to scream. I want to yell. I want to throw things against the wall. But all I can do is keep it inside for the rest of my life. Thank you.
Could you state your name for the record?
Hussein Murray.
Good afternoon, sir.
Good afternoon. I just wanted to talk a little bit about my dad first, is that he was kind and warm. He was a very brave man, especially after caring for my grandmother who was dying. He became gentle in a way that I had never expected. And he did that at the age of 70 years old, I might add. He was the rock that our entire family could depend on. You know, he never let anyone down. He sacrificed his whole life. He never really took vacations, never had fancy things, never had fancy cars, extravagant dinners. He always made sure that everybody was safe and secure, cared for. Unfortunately, he was just in the time where he was starting to enjoy his life and plan on retirement, just now starting to go on vacations with his grandkids, but that tragically ended. And in this impact statement, he is the primary victim. His life was stolen. He'll never get to see his grandkids graduate college or have their own children or get married. He'll never get to enjoy his retirement with my mother, who's also a victim in this crime. She has had to endure trauma, a loss I cannot even imagine, losing someone that you've been married to for that long, dedicated and lovingly. Also, I can't imagine the way she feels the violation of the sanctity of her home, some place where you're supposed to feel refuge and safe. I hope that she has that feeling, because I don't know if I would ever have it again. She'll never get to see his warm smiling face or his warm embrace. We will never have the safety of knowing that he has had our back because he's no longer with us. My family has had a significant impact emotionally. We have suffered, school has suffered from depression. My daughter has had trouble making friends. I have had severe depression. My father was my hero, and I couldn't get the idea of his murder out of my head whenever I would remember him. And that is something that I will never forgive the defendants for, because anytime I remember any of these warm, wonderful things about my father, I also think about his last moments of terror, thinking that my mother is going to die as well. I will never forget that. And I hope that the court takes that into its determination today. And my broader family, everyone has been devastated. Every day we go to work is a trial of our patience and our fortitude, because everything there is tainted with his presence. He filled the place with joy, and his presence is missed every day. I would say that someone could be forgiven for something like this should they ask for it, but I don't see that the defendants are remorseful in the least. And I would also hope that the court would take that into consideration. Another consideration I hope is taken into account is that he is the second jeweler to be murdered in as many years over money. I think that in order to make sure that this doesn't happen, we need to make sure that all parties that are accompanied to this crime are prosecuted to the full extent of the law. That's my wish, I hope. That's it, thank you.
Please state your name for the record.
Thank you, Your Honor. Abdu Murray, the eldest son. I'm Abdu Hussein Murray, the eldest son of Hussein Abdu Murray and Linda Murray. Your Honor, you've heard enough statements of the way crime has shattered families to last you a lifetime. It's part of the burden you bear as a public servant. It's a burden I am grateful you have the fortitude to bear for us. Sentencing is a time when we imperfect vessels of justice try to fit the sentence with the crime, with the consequences with the sin. And that's what's happened here. It really is sin. We call it crime, but it's a sin. It's a grievous sin, a sin that took a vibrant life, never to be replaced on this side of heaven. A sin that shattered my mom's life and her sense of security. You know, my dad was larger than life. He was generous to a fault. He was strong as an ox, and he was brave as a lion. And with one act of trust, based on one act of deceit, planned deceit, the lion that protected my mom was slain. Carlos Hernandez and Joshua Zuazo robbed my mom of her lifelong companion, her husband of 54 years. They snatched away his grandkids' futures of seeing him light up a room at their graduations, at their weddings, at the birth of their kids so he could have grandkids with my mom. Our very large family looked to him in so many ways, emotionally, spiritually, financially. So when they robbed my mom of her husband, they robbed us all. My brothers and I were robbed of our hero, our counselor, and just dad. But another robbery happened after my dad's murder, and that was the robbery of our dignity. You know, Carlos Hernandez and Joshua Zuazo are guilty of this sin. They're guilty of this crime, and it was obvious. It was painfully obvious. So very obvious that it took the juries less than an hour to convict them both. The mountain of evidence leading to a guilty verdict was absolutely inevitable. Absolutely inevitable. And of course, I believe strongly in the defendant's right to a fair and just and speedy trial. And this court did an amazing job of ensuring that they got that right to be exercised. It's a right that I believe in heavily. It's a right for every human being and every citizen of this country to have, and I would defend that right to a fair trial. But just because you have the right to a fair trial doesn't mean making us sit through a week of it was the right thing to do. It was not the right thing to do. They could have exercised another right, and that right is to plead guilty, to own their sin, to do at least one thing that could have been a testimony to this community and their families and everyone else about what it means to own sin, to own up to the consequences and to bear those consequences. Instead, they chose to make my mom sit in that box and testify and relive the worst day of her life. They chose to make us relive our private hells. They chose to make us watch and hear and listen to forensic evidence about the violent way my father met his end at their hands. They chose to make us sit through text messages where they planned a heist that would get them the house of their dreams and the yard they've always longed for. My mom and my dad, who came from virtually nothing, worked their whole lives to get the big house and the yard. And Joshua Zuazo and Carlos Hernandez descended upon that house with envious eyes. And they made us sit through a week of that at the trial. Not to mention the preliminary hearing. All the while knowing they were guilty, but banking on the slimmest of chances, and the chances were exceedingly infinitesimally slim, that they would get out of that guilt, or that they would get less than the maximum sentence. What that tells me, Your Honor, is that there is not yet any repentance in their heart for the sins they have committed. And that tells me that they have not yet fully come to terms with the enormity of the damage, with the size of the crater, with the vastness of their sin. It tells me that the only way they will ever really truly understand the depth of what they've done to us and to the community is for them to spend the rest of their lives in prison and never get out. Their sin has lifelong consequences for us, and their sin should have lifelong consequences for them, and the law of the land provides for that. And maybe then, and this is a hope I have for you guys, maybe then you'll see what happened, the depth and the consequences of this whole thing. I don't think it's going to take anything less than sitting in jail for the rest of your life to do that. I really don't think so. And when you see that, then maybe there can be repentance. One of my favorite lines from a book asks the question, is everything sad going to become untrue? What a line. Is everything sad going to come untrue? My faith in the Savior of the world tells me that yes, eventually everything sad will become untrue. But until that day, everything sad will stay true. And it will stay true because of what they did. And while those sad things remain true, Your Honor, these men need to bear the consequences of what they've made true, of what they've made sad. My dad is gone. My kid's grandfather is gone. And my mom's husband is gone. For justice's sake, for the community's sake, for our sakes, and I dare say, for their sakes, they need to feel the weight of their sin to the fullest extent the court can give it. And hopefully then, when all is seen, and what is sad is now true, maybe, they'll acknowledge it and see the depth of it. Thank you, Your Honor.
Thank you. And I would just like to say, your dad sounds like he was an incredible man. Everything that you guys have said and everything about his story, just someone who worked so hard to provide for his family. And that rings true with this court. And the court gives you and your family its deepest condolences.
Thank you. Thank you, Your Honor. Thank you.
Anything else by the people?
There's nothing left for us to say, Judge.
Understood. All right, so Mr. McCarthy on behalf of defendant Zuazo.
Well, Your Honor, the sentence that has to be imposed is mandatory. Mr. Zuazo and I discussed his right to address the court here this afternoon when we met on Saturday. My understanding is that he will decline that opportunity. He intends to appeal his conviction, but is not going to be saying anything on the record today.
Okay, all right, Mr. Zuazo, this is your opportunity to make a statement to the court. Anything you would like to say? Ms. Lofton, any allocution on behalf of defendant Hernandez?
Yes, Your Honor. As to count one, obviously, as Mr. McCarthy has stated, the court is not given many options. As to count 2 and 3, guidelines are scored at the bottom end of 62 months to 228 months. My client is requesting that I ask the court to sentence to the bottom of the guidelines on count 2 and count 3. My client likewise is going to decline his right to make a statement. He intends to appeal, and I do have that form filled out.
Any statement you'd like to make to the court, defendant Hernandez, prior to your sentencing?
No, ma'am.
All right, this court, having sentenced many individuals over the years, it is rarely does the court see this level of depravity, this level of arrogance and greed, because that's what that was all based on. You could care less about a man's life in order for you to fulfill the fantasy of the life that you wanted. The white picket fence, the house. His life meant nothing to you. The idea that there is such a loss of humanity in your actions. You go to his home the evening before. He looks at you eye to eye, and he's kind. Most people would not be kind at 10 o'clock in the evening. That doesn't stop you. That just alters your plan to go back the next day. And you go back the next day with the intent to deceive and invade. And every single step you could have taken to change that at that point when you walked in that house, every step on your way to that basement, on your way down with him, you could have said, okay, enough is enough. It's gone too far. But you couldn't, because it's a cowardice act, because that's exactly what you are. It is pathetic. Your actions are absolutely pathetic. You thought you came up with this brilliant plan. You boasted about it in messages, that you had it all figured out. There's signs, there's timing, you got it all figured out. What you didn't realize was every single thing that you did, every little pathetic cowardice act that you did, left to a trail of evidence that ended up being copious amounts of evidence that led in very quick convictions with 2 separate juries. None of us know exactly what happened in the basement when you 2 went down. Obviously, we didn't have a video to be able to see it. We see the aftermath of what happens when you go down there. But I am certain that Mr. Murray fought you with the courage of a man who spent his life protecting his home and his family. And I hope whatever those last words he said to you, or whatever that last moment that he looked at you, haunts you for the rest of your life. Because you see, 1 breath of Mr. Murray's life doesn't amount to 1 ounce of your dignity or worth. He was a loyal man. He was a hard-working man. How dare you? It is the sentence of the court as to defendant Zuazo, as to count 1, homicide, felony murder, habitual for the defendant served his natural life in the Michigan Department of Corrections without the possibility of parole. As to count 2 and 3, it's unlawful imprisonment as a habitual 4. It is the sentence of the court. The defendant served 228 days to 80 years in the Michigan Department of Corrections with the 421 days of credit. Restitution is $2,819. State cost is $204. Crime victim rate is $130. You have an absolute right to file an appeal with the Michigan Court of Appeals. If you can't afford an attorney, the court would appoint one for you. You have 42 days to make that request. As to
Judge, may I interject?
Sure.
You indicated 228 days.
228 months.
That's what I thought.
Thank you.
Thank you.
As to defendant Hernandez, this is case number 2024-291945. As to count 1, it is the sentence of the court. The defendant served his natural life in the Michigan Department of Corrections without the possibility of parole. As to counts 2 and 3, it is the sentence of the court. The defendant served 228 months to 80 years in the Michigan Department of Corrections. He'll receive his 423 days of credit. It's $28.19 for restitution, $204 for state costs. Crime victim rate is $130. And I didn't say this, I know Mr. Zuazo was removed. It's no contact whatsoever directly or indirectly with Linda Murray and or the Murray family. You have an absolute right to file an application for leave to appeal with the Court of Appeals. If you can't afford an attorney, the court appoints one for you. You have 42 days to make that request.
Your Honor, as to Mr. Zuazo, who has been removed from the courtroom, he executed the request for appellate counsel form, and I'm going to hand it to your clerk before I leave.
Okay, and Mr. McCarthy, do you want him brought back in for you to say that in his presence? Because I'd be happy to do that.
If we could do
Okay,
that, that
then
would be great.
Let's bring him back in. And Ms. Lofton?
And for the record, Your Honor, my client has also executed his right to appeal, and he will be tendering that to your clerk. Okay?
Thank you, Your Honor.
Of course.
I don't, can we just approach for a second?
I did. They said 2819. In my mind, that's in my mind. But let's make sure we get it proper right. Did you need anything addressed with Hernandez prior
No,
to him
thank you.
leaving? All right, and then Mr. Zuazo, your attorney indicated that you did actually sign your appellate rights, is that correct?
Yes.
Okay, and if the court didn't order, you were to have no contact directly or indirectly with Linda Murray and or the Murray family. You got restitution in that amount of $28.19, state cost of $204, and crime victim rate of $130. Counsel, anything else for the record?
Just for both defendants, the restitution is joint and severable.
And I'm giving Mr. Zuazo one of the forms that he signed so that he'll have it in his file going forward. And I'll give the other copy to your clerk before I leave the courtroom.
Excellent.
Thank
Anything
you, Your
else?
Honor.
No, Your
No,
Honor.
Your
All
Honor.
right,